New Year's resolutions to help you win in small claims court in 2026. Coming up right after this.
Yes.
Hey everyone, welcome back to the Mr. Small Claims Court YouTube channel. This is Jordan Farkas. Very grateful to have you. I am a retired attorney who practiced extensively in small claims court and have authored many books, including books on small claims court procedure. And in today's video, I'm going to discuss New Year's resolutions that you should make if you want to win in small claims court in 2026. Actually, I should probably say if you want to avoid small claims court in 2026, but that goes hand in hand with winning in small claims court, as I'll get into. Thank you for all those who subscribed since my last video and all who have subscribed in general. If you haven't yet subscribed, I'd be very grateful if you took a minute to hit that subscribe button and the notification bell so you don't miss a future video. It encourages me to continue producing videos just like this one, and to hit the like button. Share this with anybody who you feel can benefit from this video. I really appreciate it. Now, as I said, today's video is going to be about New Year's resolutions for 2026 to win in small claims court. It is January 1st, 2026 as I record this. And as usual, I'm going to get right into it using my trusty whiteboard. Now, those who have watched my previous couple of videos will know that I was kind of complaining about the size of my whiteboard. I couldn't find my older one, and I said I had intended to get a new one, which I did right over here. It's not much better. As you can see, I kind of have to shift over. Maybe I still bought one that's a bit too big, but I wanted to have enough space to write my notes on. So without further ado, in any event, I'm going to jump right into it. So let's talk about these New Year's resolutions. Like, what do I mean by that? So let's go. Number one, get it in writing. So this may be obvious to many of you. I tend to say that a lot. A lot of times certain things are obvious. They're right in front of our eyes, but we forget about them in the heat of the moment, if you will. And probably the most obvious thing for proving a claim in small claims court is to get something in writing. Moreover, not just proving a claim in small claims court, as I alluded to, but actually helping you avoid court. Because when you have things that are clearly documented in writing, things are that much less likely to go to court because there'll be a clear understanding between the parties, between you and the other person. In fact, a lot of people think that making a contract is just about having something to rely upon if you have to go to court to sue. And that is true to a certain extent, but more importantly, and I talk about this a lot when I talk with colleagues and friends, more importantly is the contract in the sense that it allows you and the other side to really come to a clear understanding of things so that you can avoid having a dispute in the first place. And probably one of the most common issues for people going to small claims court is that they don't have a clearly outlined contract. Okay. Now, I do understand that sometimes contracts aren't feasible or they're not applicable, especially if it's a smaller dispute over a couple $100 or something of that nature. But still, you should always do your best to have a clearly signed contract. And if you don't have a clearly signed contract, or it's not practical in the circumstances, then second best is to have your emails and or text messages, however you're communicating, to be in writing. Do not rely on a handshake agreement. Do not rely on verbal promises. You should always get things in writing. And even if that means a text message, you want to make sure that you have a clear trail that's outlining the agreement that you came to with the other side. And again, that can help you avoid court, because if you can show, sometimes people obviously are just completely irrational and it's impossible to deal with them, and I understand that. But some people genuinely feel that an agreement was something other than how you feel it was. And if you can point to a clear path of what the communications entailed, that will help you avoid court, and if you have to get to small claims court, to win in small claims courts. So getting things in writing in a more organized fashion than maybe you've done in the previous years should certainly help you stay away from court or win in small claims court. That's number one on the list. Number two here on my trusty whiteboard is to put yourself in the judge's position. Now, what do I mean by that? So I'm referring to the small claims court decision maker. In some courts, the judge, the decision maker will be referred to as the judge. As I've mentioned in earlier videos, oftentimes it will be the deputy judge, justice of the peace, magistrate. There's all sorts of different titles for the person making the decision. But the bottom line is that when you are negotiating and dealing with another person. And again, we're talking about before you even get to filing a lawsuit. Okay, we're trying to help you win in small claims court or avoid small claims court before you even get to the point of having to file a claim. You want to try and see things from all angles to the extent you can. Now, obviously, attorneys are more trained to do that, especially with legal training. And I'm going to get to the idea of consulting with an attorney at the bottom of this list. Is 5 points on my list over here. But for our purposes, anyways, do the best you can to leave your shoes, if you will, and see how the other side is looking at the matter and how an objective person, a bystander, if you will, may analyze the understanding between the two of you. Okay, because something that may be very clear to you in your mind, even when you're texting something, may not be perceived that way by the person on the other side who's reading what you're communicating. So this goes hand in hand with getting things in writing, but it's adding an element, which is to really try and put yourself in the shoes of the person on the other side of the table, to really try and make sure that things are as clear as possible so as to avoid misunderstanding. How would the person on the other side of the table perceive what you're saying? Are the terms clear? Is the amount of money to be paid clear? Okay, a common example of where things go awry are for change orders, let's say when you're hiring a renovator. Okay, so in a renovator's mind, it's like, okay, yeah, the agreement calls for a certain countertop, but now you're asking for a more expensive countertop. And a lot of times in the homeowner's mind, it's like, no, I contracted for a countertop. A countertop's a countertop, and this is the one I want. Okay, so that's kind of an idea. Okay, if you're a homeowner, you can say to yourself, okay, how would a renovator look at this contract from their perspective? How are they reading this? And as a renovator, you can also get inside the shoes of the homeowner. How would the homeowner look at it from their perspective? And you can use that kind of magnifying glass of, zooming in on somebody else's perspective to help you have a more clearly detailed contract and or understanding with the other party. Okay. Now, I should mention, I mentioned this in the last video, I think, that there's different perspectives depending on if you're looking at this from a defendant's perspective or plaintiff's. In other words, these videos have by and large been from the perspective of the plaintiff, the person who wants to sue, the person who feels that they're owed money. From a defendant's point of view, there's all sorts of other recommendations, and that will be the subject of a future video where I'll get into the idea of, if you're a business owner and you have invoices that you're issuing, the invoices should be in compliance with the law. They should make it clear what the terms are. They should have like boilerplate templates to avoid getting into lawsuits, okay? But, a lot of times that's from a defendant's perspective, because a lot of times the people that are hiring them to do the work, for example, I keep using the renovator as an example. If you're a renovator, you should have like templated types of invoices and contracts that you're using that really incorporate all the various ways in which things could go awry. And you should build that up as you go through your experience. Okay. I used to represent a very large builder, for example, who got sued constantly. And I used to think to myself, man, they could really use a tutorial on how to avoid lawsuits. If I just pointed out to them what issues keep arising over and over again, they could really avoid these petty lawsuits that people are bringing against them. I say petty because for the builder who's dealing in millions of dollars, small claims courts disputes were petty for them. For the person bringing the lawsuit, by all means, if you're that person, you have a right to sue for what's owing to you. But if you're the builder and you're dealing in $1 million projects and you have to deal with the small claims court lawsuits being filed every other week, then that's a problem. And that's something that really has to be curtailed. So the point I'm making is that if you're somebody who gets sued a lot, then part of your resolution to be to build in systems that will help you avoid that. But if you are a person that maybe you're not a person who sues a lot, but if you're a person who finds that you've been in various disputes and you wish you would know how to avoid these disputes for the future going forward, then this video helps you in terms of making these resolutions, as I call it, to try and avoid getting to court, or at least being better protected in the event you do find yourself having to sue in the small claims court. So that's point 2, which is to try and see things from the other person's perspective. Point 3 on this list is to avoid emotion. And this is a very important one because I can tell you the majority of my clients in small claims court were so emotionally charged that it was very hard for them to see the forest for the trees, or is it the trees for the forest, whatever the expression is. And oftentimes they would get on the phone and they're telling me about their case, and 99% of it was all the emotional component, and the actual, meat and potatoes, if you will, of the case, which was what I was interested in as a lawyer, they would kind of be glossing over. And it's actually the reverse. What you want to do is you want to leave out your emotions. So let's say, for example, you see your blood starting to rise because you see that the person that you're dealing with is, not doing what you feel they should be doing under the agreement that you had with them. They're simply not paying you, or they're not performing the work that you hired them to perform. It's very easy to start sending all sorts of nasty text messages, making all sorts of threats that you'll never keep, or maybe you will keep them, but let's leave that aside. But making all sorts of threats and getting all nasty and emotional and saying things that you'll later regret. And you'll later regret it because if you get to court, you want to be as professional and you want to be as proper and professional as possible for the judge, for the decision maker. Judges don't want to get into this emotional component. Don't forget the decision makers are looking at thousands, maybe not thousands, but it depends on the court and the jurisdiction that you're at, but they're looking at tons and tons of cases. So they don't get moved by your case any more than they get moved by another case. And that's going to be, I don't know if I've done a video on that, on how to sort of speak to the decision maker at the small claims court trial. Okay, that I also talk about the idea of leaving emotion at the door. So same thing when you're communicating with somebody where you kind of see that maybe there's a dispute on the rise. A good resolution for 2026 is to avoid escalating things in that way. There's the expression, you catch more bees with honey. Yes, there are some sort of exceptions sometimes where some people only understand the language of talking tough. I get that, but talking tough doesn't mean you have to start calling them names or making ad hominem attacks. Okay, so you really want to avoid that. All it does is hurt you, and it takes away from your ability to focus on what the dispute actually is, so that if you have to sue in small claims court, you can stick to the issues and be that much sharper and better prepared. Also, as a person, if I can add, in general, from a personal development standpoint, it's better to try and keep the peace to the extent you can, even if somebody's doing something that you disagree with. Okay, we're not angels, and I understand we get angry and upset at people. I totally get that. But the more you can work on sort of letting go of the emotional component and just seeing it for what it is, which is ultimately a business dispute. That's what's underlying all of this. That's why we're here. That's why you're watching this video, because you want tips and guidance for winning in small claims court. You really want to leave that emotional component out the door, and you will be healthier for it. You'll be less stressed and you'll be calmer and have more serenity. Okay, number 4, getting to the bottom of the list here, is to keep good records. Okay, so hand in hand, as you can see a trend over here, I'm talking about getting things in writing, having clear communication, seeing things from the other side's perspective. Now, this is not any good if you can't find where you put the contract. Okay, so you definitely want to keep good records, and that's a good resolution to make in 2026, to keep better records. That may mean making sure that if there's a document that wasn't digitally done, okay, so that you want to make sure you have that scanned in. Now, maybe I sound like a dinosaur because I am a bit of a dinosaur, but maybe you want to, if there's something that wasn't digitally done and it's like a hard copy, it's something you physically received, you may want to have that scanned, maybe not may, I would say you should have that scanned in so that you have a copy and you have a record of it. And in any event, every communication that you have, you don't want to get to court and find out, let's say you have it all on your phone. You can't just go to court, maybe some courts, and flash that phone to the judge. You have to have that printed out, or you have to have it ready anyways. And if you don't know where to find it on your phone, or if a lot of the messages got deleted after a certain period of time, that's certainly not going to help you. So you want to, when you have interactions with business people or day-to-day interactions that involve an exchange of money in particular, because that's the vast majority of what small claims court disputes are over, then you want to have clear records and have a system for keeping those records in a secure place and somewhere where you can find them and access them easily. And also, when you're filing your small claims court lawsuit and you're telling your story, as long as you can refer back to those records, you're going to be in that much of a better position. That also has to do with, by the way, photographs, right? So let's say you hired a contractor to do work on your home and the work is shoddy and you want to get that work repaired. So bear in mind that you want to have good records as far as photographs. So you want to take photos, snap some with your phone and make sure you keep those photos in a place where they won't get deleted, and that you know where to access them and find them. So those are just a couple of examples of keeping good records, but that's the key. The key is to be as organized and be systematic as possible. Okay, so that's number 4, is to keep good records. And finally, number 5, and this comes up a lot as well, and maybe I'm somewhat biased, consult an attorney. Okay, so in my last video, I talked about the idea of consulting with an attorney, even for small claims court. And obviously, this will depend on the amount of money in dispute and the jurisdiction that you're in. Of course, I recognize that many small claims courts, lawyers are not actually allowed to represent clients in small claims court. But nevertheless, a lot of the small claims court issues, as I talked about in the previous video, are similar to larger court disputes, just on smaller amounts. Now, if you have a case that's like $50 or $100, then it's not going to be financially feasible to consult with an attorney unless that attorney offers a free legal consultation initially. But even those, they don't tend to really give you a lot. They're kind of sort of, most lawyers, and I don't want to speak for all lawyers, but most lawyers do it as a way to kind of get you through the door so that you'll retain them, hire them for their services. Okay, but assuming the amount of money is enough to make it worthwhile to get a lawyer involved, I do recommend speaking to a lawyer, because why leave things to chance? A lawyer will understand the law, will understand how you should maybe approach things from a litigation perspective. They can look at your documents and your evidence, tell you if you have a good case before you spend all that time and money suing in court. Okay, so consulting with an attorney is a good New Year's resolution to make for 2026 as well. It doesn't mean you have to hire a lawyer if it's a jurisdiction where lawyers are allowed in small claims court, but either way, it doesn't mean you have to hire one, but just having that consultation so that you can get a better understanding of the nature of your case, again, assuming that it's financially feasible. I'm not suggesting, spending a lot of money on a lawyer's consultation that's more than the amount that's in dispute. Okay, so just to do a brief summary of our 2026 New Year's resolutions to win in small claims court. Number one is to get it in writing, make that a habit of having a clear trail, a paper trail, if you will, whether that's an actual contract, which is always the best. I shouldn't say always, almost always the best, or it's email or text message communications. Have it in writing. Number two is to put yourself in the judge's position. When I say the judge, I mean like an outside objective observer who may be making a decision. How would the other side see things? How would a third party look at things? That will help you, kind of refine what the understanding is between you and the other party to make sure things are as clear as possible to avoid small claims court, or in the alternative, if you have to go to court, you will have covered your bases as much as you can. Number three is to avoid emotion. So if you do find that things are starting to escalate, the person's not paying you, the renovator's not doing the work, leave out the emotional component. Don't start calling the person names or yelling or anything like that. You want to be as calm, cool, and collected and centered as possible. Number four is to keep good records. So when you do have those written communications, as I spoke about, or photographs, you want to know that they're in a place where they're not going to get deleted, where you can reference them when you're going to court and use them as evidence to help support your claim so that you can win. And number five is to consult an attorney. Once again, assuming it's financially feasible, it can be very useful and helpful to have somebody with legal experience who could counsel you, which can give you an upper hand when you're going to small claims court. So I hope you found this video helpful. Hope you're having a wonderful new year. Once again, if you like this video, I'd appreciate it if you hit that like button and subscribe and hit the notification bell. You don't miss a future video that way. And you definitely encourage me to continue producing videos just like this one. I'm so grateful to all of you who subscribed. I'm grateful to all of you, anybody who's watching this video or listening to it as you do some chores around the house or working or whatever you're doing. I am very grateful, but I'm doubly grateful if you do hit the subscribe button. And of course, if you have any feedback, I almost forgot, if you have any feedback or comments, what your New Year's resolutions are to win in small claims court, I'm always curious to hear from you, the audience. Once again, thanks for visiting. And until next time, I look forward to seeing you at the next video, and Happy New Year. Hey, thanks for watching. If you found that video helpful for winning your small claims court lawsuit, then you're not going to want to miss a future video. Hit the like button, the subscribe button, and the notification bell. It takes a second so that you don't miss a future video to help you win your small claims court lawsuit.